can, over time, and we've now enough time since 1995 when the directive was first adopted, has passed, that you can spot these cultures in different countries. And I think the Commission had to give in to that idea that this had now gone so divergent that there was a need for further harmonization, both from the point of view of the individuals whose right needs to be protected, but actually also, ironically, from the point of view of the businesses, because businesses are now much more globally active, and they found it quite difficult to comply with these different data protection laws. I can remember once talking to a Google lawyer who said to me, well, Google's decision basically is we comply with the German approach, because if we do that, we comply with every other country's approach as well. Now, I'm not entirely sure that very many tech companies have taken that approach, and there is a reason why so many of them have set up in Ireland, and it's not just because I think Ireland has a good tax regime. I think as far as data protection is concerned, that also plays a point. So this is another way I think where the Commission sort of realized at some stage we have to do something. So this is where we got to last January. And what Javier just said about this, DDoS attack, I don't find this surprising. I don't think anybody in the Commission finds this surprising. There is a reason why they didn't do this for 15 years, I think. This always was going to be opening Pandora's box, and nobody wanted to go there unless they absolutely had to. So I don't think that, I think we probably got to the point where the Commission felt they now had to. But it was that big step. So going forward, there are a number, and I've just really done a quick list because I'm sure we're going to talk more about the individuals. There are a number of what I call fault lines between the different countries and different attitudes and different positions of civil society campaigners and company. This really upsets the Americans. And I've been to a conference in Brussels in January where there was almost a Twitter fight, shall we say. People standing on the sidelines watching this. Basically, what the Commission is trying to do is it tries to expand the territorial scope of the regulation to countries that process EU citizens' personal data. And that is something that will very much affect in particular, big US online providers. And they find this very, very appalling because they feel that they are US companies who should be subject to US regulatory frameworks and they shouldn't have to comply with this. And this is one of the big sort of fights that are currently going on between the EU and the US, and we will see how that comes out. I found this quite ironic in Brussels, actually, because there was this US lawyer who said, well, what would you say, if we allowed you to influence our congressional legislative system and stuff like that? You wouldn't think that was right. And I was just like, well, there is a difference between going to another country and telling the other country what laws they should make for their own citizens and actually complying with, actually asking a country that's using data of your own citizens and actually asking them to comply with your own rules. So that's the first thing I would say we are going to see a lot of fight about, and that informs a lot of what's going on. We are sort of rediscussing the concept of personal data, and that is something that we had an idea about before we had online and all of that sort of stuff, and now there is a whole lot of data like IP addresses, where we are thinking, is this personal data, and what does this mean, and so on and so on. I don't want to go into detail, but that is one of the areas where we currently have a lot of discussions. We're also, in a way, discussing material scope of the legislative framework in another way, and that is who should it apply to inside Europe. And we've always had this consensus that it shouldn't apply to individuals, it should only apply to sort of, data controllers as a big thing and people who use it for commercial purposes. And this used to be called the household exception. So if you were just telling somebody something about somebody else in a purely domestic context, you were sort of off the hook. But there have been, of course, changes with social networking, that when we started disclosing information about other people in unsecured online environments, all of a sudden we were broadcasting very sensitive information to millions of people. And there is a discussion to be had. I'm not saying, I personally still don't know on which side of this I would come down to, but there is a discussion to be had how this would affect data protection law and what sort of intermediary discussions we need to have about this. And then finally, we have issues like consent, data portability, export to third countries, and the right to be forgotten. Now, for me, the right to be forgotten has made far too many headlines. It's one of those things that I'm always asked about, and I really hate talking about, because it's a concept that was already in there and that has completely I think actually colonized headlines that would be much better spent on other stuff, because there is much more dangerous stuff in the regulation and in the proposed amendments to the regulation than that. But if anyone has any questions, I will concede to talk about it. Much more important, I think, are two other things. The first one is consent. I mean, the use of consent is something that originally came entirely of this idea that is almost a fundamental rights principle. The right to privacy is the right of the individual to control their own information. It's the right to control who knows what about me. And consent was seen as this method of enforcing that right. Now, what has happened in the online environment, and as I say, I've worked as a data protection lawyer, I've written those policies. In the online environment, consent has basically gradually being reconfigured as something that works much better for those people who want to use your data than it works for you as an individual. Because the way you do this is by writing very specific privacy policies that basically say what we're going to do with this data is this, following the next 42 pages. And then at the bottom you write a piece in, by using our service, you consent that we are allowed to do this. And this basically uses or utilizes a very specific element of the human nature. When I'm signing up to an online service, I'm not doing this to read 42 pages of privacy policy. I'm doing this because I want to use Facebook. And then the final point, if I have another minute, is I think the big thing about export to third countries. There is now a big issue that, and I gave a paper on this yesterday at another conference, there is now a big issue that one of the main things that online providers are complaining about is that data protection law is making it too difficult for them to operate, to innovate, to do all the things they want to be doing, and that really the people who are suffering from this are European citizens, European consumers and European businesses, because they can't use all these wonderful services that you can use when you go into the cloud. That once their data is in other countries, the companies who hold that data or who process that data on our behalf are subject to the legal regulations of those countries in which they are established. And those legal regulations, among other things, provide access to those countries' own law enforcement services to that data. So currently we are in a situation where we are potentially creating a framework that really encourages mass transfers of data to other countries. At the moment, mainly the US, and there is a lot of really scary stuff in the US when it comes to that sort of thing. But actually, if you think this a little bit further, the cloud providers could also be set up in countries like Russia and India and Iran and China, and they might have similar situations, similar laws that actually allow their own governments access to that sort of data. And that is something that has not been sufficiently discussed.